All right, welcome to this Probable stream on the rights of the accused, Amendment 4 through 7. So let's go ahead and get started. As always, make sure to follow Think Probable on Twitter, Instagram, and YouTube. That way you get all the updates about everything that Probable has to offer with all of the different subjects, AP classes that we have. There's videos, we post constant updates about our streams, and just some stuff to keep you informed. So please make sure you're following us on all of these platforms. Just a little bit about me. My name is Akhilesh, and I am a junior from North Carolina. I love politics. I love learning more about it, and I took AP Gov as a sophomore. I got a 5 on the exam, and I'm super excited about Probable and teaching you guys to love politics is just as I do through the AP Government class. A little bit at the beginning about selective incorporation and kind of go through the College Board standards. I try to put everything that I can in my presentation that aligns with the College Board standards because eventually that's what you're going to be tested on. So that's what I think is the most important. Then we're going to go through amendments 4 through 7 and then talk about some relevant cases for each of these amendments that you might see on your exam. A lot of these are landmark cases that you will definitely need to know either for your comparison for your response or just for the multiple choice in general. We will have some checkpoints throughout so that we get used to answering those types of questions. And then at the end, we're kind of going to do a big picture overview about the criminal justice system and relating liberties to amendments. So we're going to go through the steps of the criminal justice system and which amendments relate to each step. So let's go ahead and get started. And a happy Halloween to anyone celebrating today. Before we get started, does anyone have any questions about what I've said so far with the AP Gov stream schedule or just about what we're going to be doing in this stream in general? All right, so we'll go ahead and get started. If you could, please answer the question in the poll that's been posted. It's just what FRQ is hardest for you. That will help us gauge what streams we need to do so that you guys can be successful on your AP exam. So if you go down to polls and you click, you will be able to see all of the FRQs and you can choose the one that's hardest for you. Additionally, in the Ask a Question tab, feel free to ask a question throughout the event. I will most likely be looking at this throughout the stream in order to answer questions more than I do the chat. So if you ask it in the questions and answers, I'll be sure to answer it so that I don't miss it if it scrolls through in the chat. All right, so this topic that we're going to be covering today relates to the College Board Standard of Civil Rights and Civil Liberties, and specifically amendments, due process, and the rights of the accused. So those numbers, the 3.8 and the 3, those are basically just the standards that College Board uses. So again, I kind of want to make sure that we're always referencing to these standards. So just a little overview at the beginning, and then at the end, we'll go over these again and make sure we know everything we need to know. All right, so just some questions for thought. What is selective incorporation? Can you think of any court cases that have to do with the rights of the accused? And what do you already know about amendments 4, 5, 6, and 7? So if you could just answer that in the chat, very informal, just kind of to gauge what you already know. And then we will get going. So just maybe like 2-3 word response to each of these questions so that we can kind of start with an overview and then go a little bit deeper. So we'll wait a few seconds and then we'll keep going. Right. A right to a speedy trial is definitely something that's covered within the rights to the accused. That comes through in Amendment 6. Another thing that we kind of look at with Amendment 6, the fair trial, trial by jury of your peers, all of those kind of fit into Amendment 6. And yeah, so just with selective incorporation, the main idea of selective incorporation is that before these started happening, all of the Bill of Rights were only applied to the federal government. So the right to free speech, etc., all of these could only be enforced on the federal government, but there were no limits on the states. So piece by piece, or what's called piecemeal, these amendments have been incorporated to the states. So with each case that comes up to the Supreme Court, the court can decide to incorporate a certain amendment to the states. So for example, Mapp versus Ohio. That case incorporated the exclusionary rule in the 4th Amendment to the states. So prior to that, the 4th Amendment only applied to the federal government. but after the case, it applied to the states also. So that's kind of what selective incorporation is, and we'll talk more about these throughout these slides. All right, so before we begin, this is just something straight from the syllabus. The Supreme Court has on occasion ruled in favor of states' power to restrict individual liberty, as for example, when speech can be shown to increase the danger of public safety. So we'll kind of see a public safety exception almost everywhere throughout this stream. However, in general, the Supreme Court has tended to increase the liberties of people, especially when we have a liberal court. However, there's almost always a public safety exception. So for example, free speech can be limited if there's a danger to public safety. Free press can be limited if there's a danger to public safety. All of these amendments that we're going to talk about generally have some kind of public safety provision or exception, and that's something that's kind of unique because we do want to make sure that although everyone is getting their rights, we're not preventing people from getting their rights if in that case, if there's really a danger to public safety. All right, so searches and seizures in Amendment 4. This is just a little like the actual reading of Amendment 4, the actual quotes, but what I want you guys to focus on is what's in blue. So the right to the people to be secure in their houses, persons, papers, and effects against unreasonable searches and seizures. So that's the main idea of Amendment 4. Is that there can be no unreasonable searches and seizures. And additionally, there has to be warrants that are issued, and those warrants have to be issued under probable cause. So what this means is that the police can't just come to your house and demand to search without a warrant and without probable cause that they have something to find. So if they think you committed a crime, they need to have what's called that probable cause for them to enter your house and search in order to prove their case. That's what fits into unreasonable searches and seizures. And we'll kind of go over this in detail on the next slide. So before police make an arrest, they need probable cause to believe someone is guilty of a crime. So physical evidence is often needed. So they must know, like, let's say you took something, stole something, maybe they found your fingerprint somewhere and they know you live at a certain place. In that way, that can be a way where they could show probable cause. The Fourth Amendment, like I said before, prohibits unreasonable searches and seizures. And additionally, the Constitution requires that no court can issue a search warrant unless there is probable cause. So kind of what the definition of an unreasonable search and seizure means is obtaining evidence in a haphazard or random manner. So that's what the Constitution kind of prohibits through this Fourth Amendment. The warrant that the police have must be signed by a judge. So in recent times, especially with immigrants and the more enforcement with the with ICE, a lot of times you're seeing activists that have been trying to convince others and spread the message that if someone comes to your house with a warrant, they must have a judge's signature on there in order for them to search your house. Unless they believe that there is something there that's a imminent threat to the public. So if they know you are holding a dangerous weapon, etc., they can't come and search your house unless there is a warrant that is signed by a judge. So in order for them to enter your house, you can refuse them entry if they don't have a warrant that they can show you with a signature from a judge. So that's like a piece of paper that they need to have. The other thing that, like I said, the exception is when the officer is at risk of harm and when the occupant is seriously injured. So if there's someone inside that is seriously injured, they don't need to produce a warrant in order to enter your home. So if they can prove that there's someone injured in that house, they do not need a warrant. So like we discussed before, public safety is generally where there's always exceptions to these amendments. However, in general, we do know that the Fourth Amendment prohibits unreasonable searches and seizures. The other thing that I kind of want to emphasize with Amendment 4 that will probably be on your AP exam is the exclusionary rule. So since 1914, the Supreme Court has been using the exclusionary rule. And what that basically says is if the police come into your house unreasonably, so they commit an unreasonable search or seizure, the evidence that they collect cannot be used in trial. So let's say the police just barge into your home without a warrant, without probable cause, and they take something that you stole, like you actually stole it from somewhere. If they present that in trial and you can prove that they took that with an unreasonable search or seizure where they did not have a warrant or they did not have probable cause, that cannot be used against you in trial. So even though it is something that you stole, you could be found not guilty just because they took it without following the proper law, without that probable cause or without the warrant. So the exclusionary rule is something that you should definitely remember that's related to the Fourth Amendment. And yeah, so this like little phrase right here with evidence illegally seized by the police in violation of the Fourth Amendment right cannot be used against the suspect in criminal persecution is basically like the literal definition of what the exclusionary rule is. So I would definitely make sure you are familiar with the exclusionary rule because that is important. The other thing is that it was selectively incorporated with Mapp versus Ohio. So chat, can you tell me what selective incorporation means now? Anyone, just type it into the chat. Just wait a few seconds, and if not, we'll keep going. Okay, so selective incorporation is when the federal government, they incorporate or they make the Bill of Rights, any of the amendments apply to the states. So that's what selective incorporation means. The Fourth Amendment specifically was incorporated to the states with the case Mapp versus Ohio. All right, so keep going. Yeah, so before that, it was only applied to the federal government, and now it's also applied to the states. All right, so we're going to talk a little bit more in detail about Mapp versus Ohio. This is a case that you will definitely hear either on your AP exam in the multiple choice. Not likely that it will be on your free response section because there is a specific Supreme Court FRQ. However, it is something that you should probably know. So kind of just an overview of what the case is. Dolores Mapp was under suspicion for illegal gambling activities. And what happened was the local police broke into her home and they were looking for a fugitive. So they believed someone was hiding there. They searched the house and they found obscene materials. So stuff that she should not be possessing. That was obscene. So kind of you can kind of infer what that was. Mapp was convicted of possessing that. So she wasn't necessarily convicted of anything that the police knew before. She was convicted based on what happened after the police entered her home. So she appealed her case to the federal court and she claimed basically the exclusionary rule in relation to the Fourth Amendment. Now remember, before Mapp versus Ohio, the Fourth Amendment and the exclusionary rule only applied to the federal government. So now because this was the local police and it was like not a federal crime, really the Fourth Amendment hadn't been applied to her case yet. But with this case, it did become applied. So the officers really had no probable cause to search for obscene materials. All they had probable cause to search for was the gambling stuff because that's what they were looking for. However, they didn't really find any gambling stuff. They found the obscene material, which they didn't have probable cause to search for in the first place. So therefore, that was kind of going against the exclusionary rule. So this is a picture of Mapp and there. Okay, so the result with what happened with this case was that the Supreme Court ruled that the evidence had been seized illegally. So like we said with the exclusionary rule, because the evidence was seized in like against the Constitution, that reversed her conviction. So really anything that they found illegally in her house that didn't have to do with gambling could not be used in trial because that was going against the exclusionary rule. And yes, so that's when this should say really that's when it was applied to the states. So the exclusionary rule was then associated with the Fourth Amendment, but then now was selectively incorporated to the states. So that means the Fourth Amendment now restricts both the states and the federal government. So both can kind of enforce that. All right, so just a little bit more about the rights of the accused in the Fourth Amendment. There are pretrial rights of the accused and no unreasonable searches and seizures to ensure that citizen liberties are greater than social order. This is kind of, again, something that I pulled straight out of the College Board exam description. It's basically just saying that in certain cases, if citizens' liberties can be greater than social order. So for example, with the Mapp versus Ohio case, having obscene materials is not good for social order and it still is and could be a crime. However, the citizens' liberties based on the Fourth Amendment outweighs that social orders. So there are cases, remember the kind of the opposite to this is a public safety exception. This is kind of saying before the trial even starts, unreasonable searches and seizures are what retracts evidence from the case, and that increases the citizens' liberties and limits what can be used in terms of social order. Again, we're going to talk a little bit more about the right to counsel and speedy trials with Amendment 5 and Amendment 6. And then this is something that you kind of want to emphasize. Again, this is from College Board. Protection against searches of cell phone data without a warrant has been a controversial issue, especially with the 4th Amendment. So that is an example really that you could see on the AP exam because it was straight out of the description. Another example that we're going to go over with the USA Freedom and Patriot Acts is limitations on the collection of telecommunication data. So what this is like mass companies or the government collecting your phone data, like your phone records, your voicemails, stuff like that. So many people think that goes against the 4th Amendment because really that's an unreasonable search and seizure of your property because your phone calls, what you say to other people is technically your property. So therefore, the government collecting those without probable cause can be controversial in terms of the 4th Amendment based on what we discussed. So because these are all required examples on the AP Gov exam description, I did want to go a little bit more in depth with the USA Patriot Act and the USA Freedom Act. The USA Patriot Act was passed 6 weeks after 9/11, and it gave the government new powers for basically surveillance of terrorism suspects. So obviously 9/11 was a terrorist attack. Now, after that event, the country was basically in uproar about how this could have happened. Where people that had been kind of tagged as terrorism suspects may not have been caught. So because it was passed 6 weeks after 9/11, this was kind of a huge step in the power of federal government. So the federal government gained a lot more power with this, where they could wiretap and surveil and conduct surveillance of terrorism suspects. Now, what this was controversial at the time because it allowed them to examine their records held by third parties. So this is like doctors' offices, internet service providers, I believe like restaurants and places that you went to, like they could examine those records as well, your medical records, stuff like that. And it allowed for searches of your private property without probable cause. So remember we talked about the private property being like your phone calls and stuff. That could be searched, but this also like increased the level to what they could do in terms of an unreasonable search and seizure. It was really controversial during that time. However, it was pretty much accepted because it was right after 9/11 and the country was kind of united on an anti-terrorism front. But in 2015, right after the expiration of the Patriot Act, the Freedom Act was passed. And the Freedom Act kind of limited what the Patriot Act could do. So it tried to end the bulk collection of materials by the, or metadata by the NSA. So what this means is it tried to end all the like surveillance with them collecting all of your phone data and all like the technological aspects by the National Security Agency. Additionally, there was a concept of a special advocate that was put in place with this act, and that was basically to represent the public in terms of privacy. So privacy has been a big issue recently, especially with all of these hacks, with all of these companies, and technological security, cybersecurity. However, the concept of a special advocate is kind of supposed to assist us. We will talk about in future streams that the right of privacy is not stated directly in the Constitution, but it's something called an implied power. So that definitely relates to this as well. All right. So what we're going to do is kind of talk a little bit about what the fourth, like a checkpoint of the 4th Amendment before we move into the next amendment. So if you could just answer these in the chat, that would be great. So we could kind of like know what we know and then kind of reflect on what we need to maybe review at the end. So what does the 4th Amendment prohibit? Is number 1. Number 2, warrants must be signed by a blank. Number 3, what does the exclusionary rule say? Number 4, what case incorporated the 4th Amendment to the states? So you could feel free to answer any of them, the ones you know, so that way we can kind of go over them and just get better at answering these types of questions. because these are basically like the basis of your concept-based FRQ questions, except they'll give you a scenario and you have to apply these two. What does the 4th Amendment prohibit? It prohibits unreasonable searches and seizures. Warrants must be obtained evidence by the police, like for example, without probable cause or without a warrant, cannot be used in court. And the case Mapp versus Ohio in 1961 incorporated the 4th Amendment to the states. So if you want to make note of these, please make note of these, pause the video, and we will get going to the 5th Amendment. All right, so the 5th Amendment, just again, before each amendment, I just want to copy and paste the exact amendment itself that was in the Constitution. So kind of, again, focus on those blue parts. So no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So this amendment is a handful. It has really 5 main protections that appear, and we're going to talk about each one of these, but mainly we're going to focus on the ones that relate to the rights of the accused. Before that, I do want to go over like an overview of the 5 so you know which ones they are. Okay, there you go. So the first one is it guarantees the right to a grand jury. The second one, it forbids what's called double jeopardy. So double jeopardy is being tried more than once for the same crime. The example that I know my teacher has used, and it's like a good example to use, is that let's say you murder a person. Now you can be tried, like let's say you are tried for that crime of murdering this person and you are found not guilty. So now the next time you can't be tried, once new evidence comes up, you can't be tried for murdering that same person. However, let's say you go and murder another person, and at that time you can be tried again for murder, but of a different person. So it has to be that you can't be tried for the same case, the same exact case, but you can be tried for different cases with the same count. So you can be tried for 7 different cases, 7 different times, if it's all, even if they are all like murder cases. However, you can't be tried for the murder of person A, even if like 7 times. So just kind of a little bit of a difference there. If you have questions, feel free to put it in the chat. It's kind of confusing, but just know that you can't be tried more than once for the same exact crime. The other thing is it provides protection against punishment without due process of law. The next thing is eminent domain. The government can take private property, but they must compensate fairly. Finally, the Miranda warning prohibits forced self-incrimination. So you can't just be forced to give evidence that will lead to your conviction. So that's where you kind of hear the phrase, I plead the 5th. When people say I plead the 5th, that refers to this portion of the 5th Amendment where you can't self-incriminate. So you can't be forced to give evidence that goes against yourself. Right, so does anyone have any questions on the protection of the 5th Amendment? If you do, just put it in the Ask a Question tab on the bottom, and I will make sure to answer it. We will keep going with the 5th Amendment. All right, so the main one we're going to talk about in this slide is self-incrimination. So in the American system of justice, the burden of proof rests on the prosecution. So that's based on the premise of innocent until found guilty. That's something that you will need to know for the AP exam, is that it's always the burden of the prosecution to prove the defendant was guilty. So the defendant is innocent or not guilty until he's proved guilty by evidence brought by, from the prosecution. That's something that you definitely want to go over. Basically, like what I said before, suspects cannot be forced to help with their own conviction, but there are exceptions to this requirement. So remember when we talked at the beginning about the public safety exception? The Supreme Court has sanctioned a public safety exception, and this is again straight from College Board. It allows unwarranted interrogation to stand as direct evidence in court, especially when it's something that can endanger society. So that's just something that you want to think about. Those cases are normally pretty rare, but generally just remember that self-incrimination can't happen under the Fifth Amendment. And if it does, that has the potential to affect the actual trial. And a main case that relates to this is Miranda versus Arizona. You do know, you probably do know or have heard of the Miranda warning. So that's kind of what we're going to go over next. So a man named Ernesto Miranda was a key suspect in the rape and kidnapping of an 18-year-old girl. Miranda was questioned for 2 hours after being identified by the girl. So like the girl was told to pick out which person did all of this to her and kidnapped her. And she picked Miranda. So, however, when he was questioned by the police, he was never told of his right against self-incrimination or that he had the right to have a lawyer there. And he said enough about what he did that it led to his own conviction. So he basically self-incriminated himself. Now, he appealed to the Supreme Court based on the Fifth and Sixth Amendments, and the Supreme Court reversed the conviction on his appeal. So what they said was that the guidelines for police questioning include warning of self-incrimination, warning that anything that you say can be held against you. So these are the things that are basically required for the police to say before, like right after your arrest or before you are questioned, really before you're talked to. The rights are, you have the constitutional right to remain silent and may stop answering questions at any time. What you say can be used against you in a court of law, and that you have a right to have a lawyer present during questioning, and a public defender or a lawyer that's appointed by the government will be provided if you can't afford a lawyer. So we will talk about the concept of a public defender and what that means in the future. However, yes, we do want to know that the concept behind self-incrimination and the rights that you really must be told before you are questioned. All right, so just a little checkpoint again with the Fifth Amendment. So what are the 5 things the Fifth Amendment addresses? The exception to the self-incrimination rule is mainly in cases involving what? And what case relates to the concept of self-incrimination? The 5 things that the Fifth Amendment addresses are your right to a grand jury, protection against double jeopardy, your right to the due process of law, eminent domain, which is when the government has to compensate you fairly if they take your property. So that is something that I want to emphasize, which you probably like is not going to be a major part of your AP exam, but it's still a good term to know, is that the government can take your property. However, they must compensate you fairly for it. And it must be for like something like relating to the public, a park, a school, something like that. And again, protection against self-incrimination, which is kind of what we discussed, because this stream is really about the rights of the accused. The exception to the self-incrimination rule is mainly cases involving public safety. And I don't know why that's all the way down there. And then what case relates to the concept of self-incrimination is Miranda versus Arizona. So those are just 3 of the major checkpoints that I do want to make sure you guys know for the AP exam. So we're going to go ahead and move into the Sixth Amendment. And like we have done with every amendment, I just kind of wanted to start out with the exact text from the amendment. So in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed at the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So this amendment is really the focus of the rights to or for the accused. This amendment kind of encompasses almost everything with a trial. So they need to be able to call witnesses, and mainly they need to be able to have a lawyer at their defense, whether they can afford it or not. So we are going to talk about a case relating to that right here. So some protections of the Sixth Amendment. Again, like I said, it's literally the main amendment that is designed to protect individuals that are accused of any sort of crime. So this amendment deals specifically with criminal law, specifically the right to counsel and the right to confront witnesses, the right to a speedy trial, the right to a public trial, and we're going to see later what the Sixth and the Seventh Amendment is a right to a jury trial of your peers. The right to a counsel, just like a vocab word, if you don't know what counsel means, counsel is the same thing as a lawyer. So anytime you see the word counsel, you can kind of guess that means a lawyer. All right. So specifically, we're going to talk about the right to counsel. So the part of the Miranda rights reading that the Sixth Amendment best aligns with is the right to counsel or the right to a lawyer. So we did talk about that with the stuff that the police have to tell you before they start questioning you. So they do have to tell you that you have the ability to have a lawyer here with you, or if you can't afford it, a public defender is going to be supplied. So even lawyers who are taken into court hire another lawyer to represent them. So they don't really represent themselves. You always want someone else to represent you that is more experienced in that field. The Sixth Amendment has always ensured the right to counsel in federal courts. However, it wasn't extended to the state courts until the 60s. So again, this deals with the concept of selective incorporation. The main thing that was the problem with this is that poor defendants often went without lawyers because they couldn't afford one. When we talk about that the Sixth Amendment has always ensured the right to counsel in federal courts, that means like a federal crime. So you had to have committed a federal crime in most states for you to be able to get a lawyer appointed if you were poor and what's called indigent and you couldn't afford a lawyer, or you were you didn't have like the complete literacy that was needed. Therefore, like at that time, there was really what was considered a lot of injustice happening. And we'll see with a future case with the Sixth Amendment, Gideon versus Wainwright, that's basically what fixed most of this. All right, so until the 30s, individuals were tried for capital offenses without a lawyer present. What happened was another case. This one really isn't as significant. It's Powell versus Alabama. And that's when the court ordered that the states must provide an attorney for poor defendants if accused of a capital crime. So what progress have we made? So before, individuals, like they had to be able to afford a lawyer in terms of the Sixth Amendment for them to have a lawyer present. Then in the 30s, individuals were tried, or like in 1932, the case decided that states have to provide an attorney even for state crimes if it is a capital crime. So for a poor defendant. Then now we're going to go into Gideon versus Wainwright, which is a landmark case. So this is super important. Definitely need to know this case in and out. I would write it down somewhere. Make sure you take note of all of these important landmark cases because you will have to write about them on FRQ number 3 on the AP exam. So basically, a overview of this case. Gideon was charged in state court in Florida for felony breaking and entering. He requested that a lawyer be appointed to him based on the Sixth Amendment. But like we said before, at this point, most states only allowed this like a lawyer to be appointed for capital cases. Gideon ended up representing himself, and he was poor, what's considered indigent, and he was found guilty. Supreme Court found in this case that assistance of counsel applies to defendants also in state courts. So again, this deals with the concept of selective incorporation, in which the right to a lawyer was applied to people in state courts as well. So again, always note this piece of selective incorporation is like a super big theme in AP Government. You need to know it for your AP exam. You will have questions about it 100%. Basically, what Gideon did was it applied the Sixth Amendment and its provision about being appointed a counsel to all state courts. And yes, so this is another thing, is that the courts must provide a counsel or a lawyer if the defendant cannot afford it, or like it really just they can't afford it, unless the right is competently and intelligently waived. So again, this is a quote. What that means is that if the like defendant themselves says, no, I don't want a lawyer, and this is in a mental state that is like not like normal, but they are in a like good mental state, and again like competent, they're mentally competent and like intelligent enough, they are literate and they are able to waive this right. Otherwise, a public defender must be appointed at all times. Again, this is a picture of poor Gideon. There's just kind of the main idea of this is that Gideon versus Wainwright guaranteed the right to an attorney for the poor or indigent. When you see the word indigent, you can normally relate that to Gideon versus Wainwright, or in this case, it goes with people that cannot afford their own lawyer. This case did cause significant change, not only across Florida, which was where the case took place, but also across the country, and that's something that is significant. The other provision we're gonna talk about with the Sixth Amendment is trial by jury. All major trials must be overseen by jury of peers. Before the Civil Rights Movement, a main factor that angered many people was that African Americans, when they went to trial, their jury was all white men generally. At that point, when, for example, let's say an African American woman goes to trial, those people on the jury are not their peers. So that was something that was a big controversy, something that was definitely fought in before and during the Civil Rights Movement. The people on the jury are selected through a process called voir dire, I believe. It's basically the most random selection possible, and trying to make sure that the jury does not have any pre-existing biases. Both the attorney for the defendant and the prosecution can both cross-examine the potential jurors, and select the ones they want or they agree to. So they have to agree on the ones that they believe will provide the best unbiased outlook to this case. And yes, as unbiased as possible. So again, kind of another checkpoint that I just wanted to include about the Sixth Amendment. What are the 4 things the Sixth Amendment addresses? Prior to Gideon, lawyers were generally appointed only for blank cases, and a jury of the defendant's blank is required for a fair trial. All right, so the 4 things that the Sixth Amendment addresses are the right to counsel, the right to confront witnesses, and the right to a public and the right to a speedy trial. The other thing, prior to Gideon, lawyers were only appointed for capital cases, and a jury of the defendant's peers is required for a fair trial. And I'm sorry, I don't know why that blue thing is all the way over there, but do know that before Gideon, it only applied to capital cases. After Gideon, it applied to the states and all cases. All right, so the 7th Amendment is pretty short. There's really not too much to cover, but we are going to talk about it. In suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the U.S. than according to the rules of the common law. Common law is like a British concept that we adopted. It's basically the way our justice system works. The 7th Amendment, all that's saying is it's applying the rights of the accused with the criminal cases to the civil cases. So in civil cases where the controversy exceeds $20, which at this point almost every case exceeds $20. So you kind of have to think about the context in which this was written. However, the right of a trial by jury is always preserved. So you have to have a trial by jury unless we're going to talk about it's waived, and there can't be any double jeopardy. So again, in the 5th Amendment, we talked about double jeopardy with criminal cases. In this amendment, we are going to talk about double jeopardy with civil cases. So this one is pretty short in terms of what we have to cover. But the protections of the 7th Amendment include that trial by jury exists for civil cases. Some examples of civil cases we know can include family law, like money, like to do with companies, and corporate law, when people are suing companies, etc. People are suing other people. Kind of what you see on Judge Judy almost. A lot of those are civil cases, not really criminal cases. You don't see too many of those on there. But those are just some examples of civil cases. What we do know is that this right to a jury can be waived. So let's say both parties do not want a jury, they can both, again, intelligently and competently waive this right. Waiving a right just means that they forego it. So they are like, okay, that's fine. I have that right, but I don't really want to use it. So I don't really want a jury. So then that's accepted if it's, again, intelligently and competently waived. And like I said, it acts as a double jeopardy protection for the civil cases. We know that the 5th Amendment associate that with the protections for double jeopardy for criminal cases. 7th is for civil cases. Really, the 7th Amendment, all of it is about civil cases, and that's really all there is to it. Just know that it deals with civil cases. Normally, the 7th Amendment is not one of the most important ones that you will see on the AP exam. However, it can help if you're like eliminating answer choices on the multiple choice or stuff like that. So I do definitely think it's helpful to be familiar with all of the amendments. However, some of them are less important than the others and come up less frequently on the AP exam. And generally the 7th does not. It might come up in the answer choices, especially if they ask you about like criminal versus civil cases or which one applies to which. So definitely knowing the difference would help you eliminate answer choices right off the bat. And then again, this is just talking about the double jeopardy. Civil cases decided by juries cannot be retried by any other court. And there have been no major Supreme Court rulings that relate specifically to the 7th Amendment. A lot of times we did see with the 4th Amendment, Mapp versus Ohio, 5th Amendment, Miranda versus Arizona, 6th Amendment, we saw with Gideon versus Wainwright. With the 7th Amendment, there aren't really, I'm sure there are cases, I'm sure, but there's no significant cases that have had like momentous impacts or significant impacts on the constitutional law or our society with selective incorporation. So that's kind of just something to consider. Again, like what I said, it's probably not something you will see on the AP exam, but something that I would definitely recommend being familiar with. Okay, so now we're kind of gonna do an overview of the steps of the criminal justice system, and then we're gonna talk about which amendments apply best to each of the parts of the criminal justice system. So most of us probably know the parts of the criminal justice system. If you've been through the judicial branch unit already. However, we do want to go over it just to apply them back to our civil liberties. So the first thing that happens in like an accusation kind of thing is that evidence is gathered. So when evidence is gathered, the amendments that apply include no unreasonable searches and seizures. We know that that goes with Amendment 4. Then what happens is there's a suspect is found, or in this case, the book referred to it as suspicion is cast, and an arrest is made. So in those cases, you have with Amendment 6, the right to have assistance of counsel. So those are like the two things or two first steps, and those are things that you can associate with the amendments. Next, when the interrogation is held, forced self-incrimination is prohibited. And I apologize, that should say Amendment 5, not Amendment 6. Forced self-incrimination is not allowed, and that's, again, based on the Miranda warning in the Miranda versus Arizona case. And then another thing, we didn't really talk about the 8th Amendment, but excessive bail is forbidden. The 8th Amendment, what that discusses is that there can be no cruel and unusual punishment, and there can't be excessive bail that is imposed. Therefore, that also goes with like the interrogation aspect. The next step is a trial is held. And in those cases, you have the speedy and public trial. So that goes with Amendment 6. You have the jury. That goes with Amendment 6. And double jeopardy is forbidden. Again, goes with Amendment 5. All right. And like I said, with witnesses, Amendment 6. Then finally, at the end, punishment is imposed. And we did not go over the 8th Amendment, like I said before. But cruel and unusual punishment is forbidden according to the 8th Amendment. So that's the one that would apply best to this step. So I definitely think these steps are super important. Not really for you to memorize, but to kind of get context about all of these different things that are happening. Our last thing, what we're going to do is kind of go over the College Board standards. These are literally the exact like descriptions and the exact wording from the syllabus. So what I did, I know before the AP exam, is go through I printed out the College Board's course and exam description, and I basically just annotated it as I was watching videos, as I was reading the textbook, and that really helped me, I know, be successful in the AP exam. So that's something I would recommend. But at the end of every stream, I like to kind of include a checkpoint with fill in the blanks for all the College Board standards. That way we know exactly what's being assessed, and we have had exposure to all of it. Like we know we've had exposure to all of it. So the first blank, protections of the Bill of Rights have been selectively incorporated by way of the 14th Amendment's due process clause to prevent state infringement of basic liberties. I do want you to make sure you know that selective incorporation is based on the due process clause. A lot of times this will be a question. One of the other answer choices will be equal protection clause. I assure you a ton of people will choose equal protection clause. So don't be that person. Do make sure you know which clause aligns with which. It is really confusing. I know I was really confused with it. So just kind of make sure, like making a Quizlet, something to do with vocab, that would definitely help. The next thing is the court has on occasion ruled in favor of state's power to restrict individual liberty, for example, when speech can be shown to increase the danger to public safety. So like we said before, public safety is kind of the only exception to citizens' liberties when the society itself is at major risk or major danger. That rhymed. The next standard also involves the public safety rule and the Miranda rule. Like we said before, Miranda versus Arizona, what that addressed was that with the Fifth Amendment, you can't self-incriminate yourself. However, the public safety exception allows unwarned interrogation to stand as direct evidence in court. So if there is really something that they said that could really help people solve or help the police solve something that has been an imminent threat to society, then yes, it can be used against them in court against the Fifth Amendment. But that's again an exception based clearly on public safety. The next thing with this is that pretrial rights of the accused and the prohibition of unreasonable searches and seizures are intended to ensure that citizen liberties are not eclipsed by the need for social order. So in this case, like with Mapp versus Ohio, even though she had obscene materials and she probably should not have, not great for society, sometimes citizens' liberties do outweigh these concerns. This is kind of what we talked about on that one slide earlier, so I would definitely recommend going back. I have linked the presentation slides on the green button below, but the right to legal counsel, speedy and public trial, impartial jury are all parts of this. We know that against the Fourth Amendment, we have protection, or with the Fourth Amendment, we have protection against warrantless searches. And then at the end, with the USA Patriot and USA Freedom Acts, those are where the limitations, well, really expansion and then limitation that were placed on the bulk collection of like technological property and metadata through telecommunication companies. So I don't think they will ask you to be like, describe the Patriot Act. However, being familiar with that does definitely help. Finally, we have, I believe this is the last slide, the due process clause, which remember that's what selective incorporation has to do with, has been applied to guarantee the right of an attorney and protection from unreasonable searches and seizures. This is represented by Gideon versus Wainwright. So the reason why they emphasize this specifically in the syllabus and not the other cases is because it is a landmark case. It is one of the ones you may have to write about on your AP exam on FRQ number 3, the SCOTUS comparison case. I would know these cases in and out, start now and do case by case as you go throughout the units in your classroom, or if it's semester long, make sure you review throughout second semester so that you are familiar with these cases when you go into that AP exam the first week of May. The last thing is the exclusionary rule. Again, make sure you know that. That has to do with the Fourth Amendment. And if they illegally get evidence from you without a warrant, without probable cause, then it cannot be used against you in court. So just make sure you know that term, the exclusionary rule, and that it goes with the Fourth Amendment. All right, so does anybody have any questions? All right, follow us on Twitter, Instagram, and YouTube. Thank you for attending my stream. So have a great night.